the background for this is that in 2008, the Nebraska legislature, can you hear me back there okay? Okay. The Nebraska legislature called for a study of the Guardian Ad Litem system. They funded the study, and I was involved in the study to the extent of participating with a... If I don't use this, can you hear me?
Yes. Yep. A lot of empty seats up front.
I was asked to participate as kind of on an advisory group just to help the NACC people understand, I think, at least I felt my role was to help them understand a little bit about Nebraska. So we're getting a study that focuses on Nebraska as opposed to some of the maybe preconceived notions that they might have had about things because of the new studies they've done in other states. These folks are from Denver, and they were chosen. I was also in the group that helped choose the organization that would do the study. What they did, the Nebraska legislature, they called for the study in 2008, and the focus from the legislature was to highlight approaches and innovative practices within the state, offered recommendations to improve weak areas. The NACC, they chose 5 counties throughout the state to focus on. They had a mixture of rural counties and urban counties, which meant they also had a mixture of counties where you have a dedicated juvenile court system versus the counties where the county court judges perform the duties of the county juvenile court. It also involved a mixture of counties where you have county boards or county boards of supervisors contracting with law firms to do the guardian ad litem work, which I'm not sure, somebody maybe correct me, that doesn't exist in very many counties in the state. Maybe Douglas County may be the only one at this point. I'm not sure about that.
Lancaster does too.
Adams does too? Okay,
Lincoln.
I didn't know that. And then, of course, the rest of the counties, it's court appointments, lawyers paid on an hourly basis. The organization, they used a number of different methodologies. These are sociologists that are doing this with legal backgrounds. And I'm married to a sociologist, so I understand what they do. So they used a lot of interviews with stakeholders, and the stakeholders included county attorneys, guardians ad litem, parents, caseworkers. And I want to say something about the parents. I can remember one of the discussions we had when they were putting their study together. It did seem to me that one group that was kind of being left out of the discussion to some extent was parents. And you know, I thought they should be included in this whole discussion. It seemed like they were getting the drift, but parents were included in this. Caseworkers, of course, were included. CASAs were included as stakeholders. The Foster Care Review Board was included. Judges were included in the research, and of course, children who are in the system were included in this. They used all of the typical methods of study, surveys. They, of course, took a very good look at what our existing system looks like. They did focus group interviews. They did lots of interviews, lots of surveys. They went through 15 measures that they used, and I'm not going to go through each and every one of these because I do want to get to their recommendations, but I did want to talk about a few of them, and some of them are kind of in combination with each other. I will also tell you, this is the study by Roy in this packet. And if there's anything, I don't know how you get a copy. Vicki, is she around?
It's on our website.
It is on the website? Okay. So you can look through there and you can get very specific information about how judges, lawyers, children, parents, foster care review responded to the various research tools in any of these given measures. One of the general, starting with the first one, how well does the current structure and funding mechanism for the guardian ad litem Litem representation operate. And that goes with with the number 5, which will come up later, about how the resources are allocated. The general, what I got out of this was that we have a structure that is different all across the state. We have 93 different structures because we have 93 different counties. And you'll see in their recommendations that this study reached the conclusion that that's not a good idea and that we needed a more statewide system. Caseloads, there wasn't a lot. One of the things that I found in that, what they talked about in there, is how do you define a caseload? Is it 100 clients? Is it 100 cases? They recommend it should be clients. Children should count by children instead of cases. Yes, Judge?
Is this just applying to GALs in juvenile cases?
Yes, this is, yes,
Only juvenile
GALs.
cases. All
Yes,
right.
this is just GAL. Yes,
If
Vicki?
people are interested, they also did a study on juvenile defenders.
Yes.
That is also on our website, so.
Yeah.
Mark will-
Yeah, I was only charged to talk about this study, but there was another study that involves representing juveniles.
Okay, but not GALs in other type of probate cases?
No, not in probate cases, not in custody, district court custody cases, none of that. This is strictly JAL work and juvenile court system. The caseload, I didn't see any big issues there except with the contract attorneys and probably in Douglas County. The timing of the appointment, they didn't seem to have too much problem with what we do there. On number 4, I wanted to talk about that one a little bit. And many of these measures, GALs, we GALs have a different opinion about how we do things than the other stakeholders, the CASAs and the caseworkers and the judges and the parents and the children themselves. Well, one of the things about the supervision is, once again, they get at, you've got 93 different counties, who's doing the supervising, where's the accountability, it's 93 different counties doing it 93 different ways, and GALs don't think they need any supervision. And one of the interesting things there is they talk in the study about the fact that when you're a GAL, you have a client who is the least able to talk about or complain about your representation or your work with them. You know, I know that any adult client I have doesn't like my representation. They know they can find pretty easily where they can go to complain about me, or they understand that they can talk to me and find out, have a frank discussion about, gee, Marcia, I don't like the way you're handling my case. Can we talk about it? But here you are. So you know, there's some self-supervision there because I know an adult can do that. But with children, I guess we're not thinking about the fact that they don't have any place to go with their complaint. Resources, I talked about that a little bit once again. Juvenile court facilities appropriate. And here they're talking about most of our courthouses do not have any kind of a quiet place where you can go to visit with a child comfortably. They didn't seem to think that the study, and when I say they, I'm talking about this is kind of the conclusions that they reach, that the study, that I got out of the study mainly. And that you don't need like a special little room with toys and everything, but you do need a quiet place. And of course, that can be difficult to do in courthouses, but if you use a little imagination, you can probably find a little tiny space somewhere where you can go and talk to a child. Which leads me to, when I started doing GAL work, years ago, I had that notion in my head that, you know, courts are no place for kids to be. And I've done a complete turnaround in that, and that's absolutely not true. And these kids this is their lives, and even if it is a crummy little courtroom, what does that mean? That's got 20 minutes left? Okay. if I might actually tell a funny story at the end of this, instead of the beginning. If you, but I did a complete turnaround. I mean, like I said, these are these kids' slides, and even if you don't have a very nice place to take a kid, just having them there and to be able to participate is a good thing. And that's clearly stated in this study. You're smiling.
I wanted to hear your funny story now.
Oh. You probably heard me say I didn't bring the kids to court today because I don't think they should be here. Compensation. All of you are probably interested in the compensation issue. This study, the conclusions, first of all, the facts are that the compensation at the time this study was done for hourly rate ranged from $60 an hour to $100 an hour. They also gave some information about how contract attorneys were paid, and I can dig that out if you want to see it, or you can look online to see that. They also talked about the hourly rate method, the contract method, and then the per case method, which is kind of like the contract method, where you get paid a flat fee per case. The conclusion was that the flat fee per case system and the contract attorney system were disincentives for guardians to do a good job. And so they didn't like that. They, of course, also into this theme of, instead of having 93 different systems, having one overall system, wanting the payment to be consistent. There's also a lot of discussion. There's also discussion about some counties will pay attorneys mileage if they have to go drive out of town to see a child. Some counties won't. Some counties will pay some of the lawyer's expenses. Some counties won't. So there's a variety. It's not just the hourly rate compensation that varies from place to place, but also some of the other expenses that go along with it. I appreciated there's also a discussion in there about how you get young lawyers to get the training to do a good job as GAL. I know we have the mandatory system now, but how do you really get a young lawyer up to speed and get them interested in doing GAL work as a real profession, as a long-term, rest of their legal career thing that they're going to do, instead of the way we've done it, where you get those courses appointed because you're fresh out of law school and don't have a lot else to do. And there are states out there, and this report does just give examples of how different states do things, but I'm not going into that. But one of the ideas that popped out of there was this notion of trying to help young lawyers pay off their student loans in exchange for some of the public service type things they can do, like GALs. I know that was a concept that was around when I first got out of law school. There were lawyers I knew that had gone to certain law schools that focused on public interest law, or they went to work for legal services, for legal aid programs, that were getting some of their student loans paid off because of that. It varied from law school to law school. We didn't have it here in Nebraska, but I knew that existed, and it could in the future.
How can we make that happen, like really quick?
I have no idea. No clue. Read the report. There may be some ideas in the report about how it's been done in other states. Seriously.
Or get mine paid off.
Yeah.
Judge Clark, talk to the county about that.
There we go.
Judge.
Training. Training, of course, we're all aware, and at this time our training had been instituted, our system had been around, and the NACC was familiar with it. They did say that we need more training and it needs to be more multidisciplinary. Yes, Judge?
Stepping back, the compensation issue, did they come forward with any recommendations? For instance, the only case, I guess the case I've relied on in the past, is State versus Ryan, when the district judge didn't want to pay the public defender to come from Lincoln and pay the mileage, and they ran into a somewhat tight-fisted district judge. Is there anything else on the books that gives us guidance on that?
I don't know about guidance. I will say I was reviewing the Supreme Court guidelines for JALs, and there is a provision in the Supreme Court guidelines. It says the Supreme Court may set out some rules that makes it more across the board, or set the fees across the board. I look at the Supreme Court guidelines, I can't quote it off the top of my head, but talking to the Supreme Court about it is one thing to do. But this would not be the year to do that, since we're looking at, closing county courts allegedly to fix the budget issues. This next one, what are the processes in place to provide guardian ad litem access to investigators, experts, and social workers? One of the, in the what are we not doing right area that will come up as a summary, we GALs are not utilizing our own experts, investigators and such as well as much as we should. Well, that may be true, but the one of the problems with that is, please, somebody tell me if you've ever been able to find a social worker who will work for you as an independent expert in a case. I've looked. Can't find it. Now, and I might have a better shot at it than most people do because of UNK and a very good social work department there. But they don't have a graduate program, so they're not fully trained. So, and plus, this doesn't address, money's, find the money. How do you, I can get, it's my experience, if I say, Judge, I needed an independent psychologist or psychiatrist or something like that, I can find them. But to find a social worker who will do a home study for me, ain't gonna happen. So, and it, of course, the study doesn't address the lack of, we don't utilize them enough, but it doesn't address very well the lack of people out there and available to do the work. Processes to, let's see, number 10. This was what this was all about, and there's this whole section, 9, 10, those, there's a very, very, a lot of the study was about this. But one of the things in there is where the GALs are criticized for not talking to teachers, for not going to, not even knowing whether their child has an IEP, or not going to the schools, not getting those records. The GAL, this is another one of those areas where the GALs, we all think we're doing a good job in that area, but the kids don't think so. The teachers don't, the other stakeholders don't think we're doing a very good job on researching our kids. So there were remarks from the kids in that part of the study, if you want to read them. My GAL, there were everything from I don't know who that person is, to they don't have any idea how well I'm doing in school, or what my grades are, or anything like that. Not that there weren't some kids in there, the study also that said, that GAL was the best thing that ever happened to me, but generally speaking, we're not getting that information, and we should be able to get, it's one of the easiest things to get is those reports, and of course, the orders that we get when we get appointed as GAL has the language in there, it says we're supposed to have access to all kinds of records. And part of that is that old relying on the caseworkers and relying on and not doing our own independent investigation. That's still an issue. The relationship between the guardian ad litem, juvenile, the system, that has a lot to, well, let's see, I'm moving ahead without punching. I'm not going to talk about those two really. Number 13 is, I don't want to talk about that one very much either. But number 14, that's the biggie. The nature of the relationship between the juvenile and the guardian ad litem. That's a very lengthy section of this where you had and it was very clear that this is where they talked to the kids in the focus group interviews and got them talking about, do you know who your guardian ad litem is? How often do you see the guardian ad litem? And the conclusion is we're still not doing a good job of that, or we're not doing a good job of meeting with our clients regularly. We're not taking them to court. We're not bringing them to court. The child is not, the perceived relationship is that we're just really not part of their lives. We're not advocating enough on their behalf, which means we're not looking at whether there are some motions we should be filing. What? Yes.
I think part of that stems from, sometimes I think the child is a little unclear on what our job is, and sometimes I think we're a little unclear about what our job is.
Mm-hmm.
Are we advocating for what the child wants?
Now there's a
Or
difference.
are we advocating for what is in the child's best interest? And I'm not always sure that the judge who appoints us makes it clear what they want us.
Well, if I back up, the relationship between the guardian ad litem and juvenile legal counsel, they are two different things. In a GAL, you have the dual role. You're the best interest person, but you're also an advocate. You're a lawyer, but you're not the lawyer who represents the child when the child says, "I'm not going to do that."
And I think that's a problem, though. I think that's what the children think that we're there for, and that I think that is why some of the results are what they are.
What I really want is to be able to quit school and do what I want, and I want you to get this case dismissed.
Well, how many times have you had to tell a client, you can't do that?
Well,
There you go.
Exactly.
But we're talking also backing up from, we're still seeing some of the basic stuff, they're not visiting their clients, not advocating for appropriate permanency, not making they're not doing independent studies, they're not using independent experts, et cetera, et cetera. I mean, that's still in there as one of the issues. I want to get to this last one we've already talked about that. To what extent are the children participating in the court proceedings? I already said I was one that used to say kids shouldn't be in court. Now I understand they really do need to be there. This is their life.
Is that just best practice to have them there?
Yes, that's considered. And the study, if you look at the study, it goes through, this is what's happening in Nebraska, this is what people think about it, and these are what some of the best practices are around the country. Did I interrupt your question? I'm sorry.
No, I just know that we've had some people tell us, oh no, the kids don't need to be there. And when I was looking up the information, it was all through this. And I just didn't know if there was statute or, I don't think HHS has rules and regulations, but I was pushing that we just feel it's best practice through this initiative.
Best practices, children should be there.
Marcia, I have a question
Yeah.
about that too. Do you, and I do understand that.
We're not talking about babies here.
No.
Yeah.
But I understand that point of view, but what about when we get to the point where we're discussing the downfalls of the parents and how they do, should the children be sitting through that?
I think,
I don't agree with that, I guess. I don't think that that's
Well-
conducive to a reconciliation between the child and the parents. We talked earlier about how kids will triangulate. They're gonna be using that. And I'm not
Vicki,
sure.
you have a comment about that. I'm not think we're talking about a termination of parental rights.
I'm talking about review hearings. When
Okay.
we talk about how the parents are progressing or not progressing, and should a child be
I don't
sitting
know,
there
should a
listening?
child be? Vicki, you had your hand up
Well, I was
first.
just gonna say two things. We did a study on the impact in Lancaster County, and kids were not harmed by being there, and they all want to be there, but what the foster youth council, what the kids say, and they said it last year at the summit, that what they would like in those cases that you just talked about, if something bad might be happening, they would like the judge to ask them to approach the bench, and they would like the judge to say to them, we're going to now start talking about your parents and how they're doing, and it may be unpleasant. And they said they would then decide whether they wanted to stay or not. We're talking about older kids, and they said the reason they would like that is because there are two reasons. One is when they're just asked, in Lancaster County, sometimes the judges just excuse them when they think it's going to get nasty, and they don't know why they're being excused, and they don't know imagination of what might be discussed rather than what it is. And the other thing is there were several kids that they said it at the summit in these meetings, that their parent was telling them for years, they talked about one of the kids there was in Judge Thorson's court, and he said, Judge Thorson, I used to hate you because my mother used to say that you was doing everything right and that you were not letting me come home. And I used to think you were the worst judge. And then all of a sudden, I was supposed to go to court, because they started having people come to court. And then I found out that my mother was actually not doing what she said she was doing. And even though it was upsetting, I wouldn't have known that had I not found
I'm going to interrupt you, Vicki, because I had two other comments, and I was also trying to find a quote from the kids, but I can't. Judge Clark.
I'm of the opinion that the kids should always be there.
Okay.
Yeah, if there's a problem, as a GAL, you can ask to excuse. Frequently, I'm surprised how young some of these kids are that want to step up front and tell you what they think's going on. And they need to understand they're the reason we're there, and we do need to hear from them.
Okay.
They know
All right.
what's going on anyway.
Okay. All right, let's get to the summary so I can tell my story before you go home. Strengths. Strengths, we have some strengths. Children have a statutory right to a GAL. GAL is appointed in every case. GALs are licensed attorneys. The appointment happens very soon after the case is filed, and that's true. That was true across the board. GAL is present for almost all court appearances, and I can't imagine when you wouldn't be, but apparently there are some. Problems. I think we've talked about some of these already. GALs are not visiting their clients, not zealously advocating for appropriate permanency placements, not making their client's position known at the court, even though it's best interest model. You still let you could still put in your court report, child wants to do this, even though I don't think it's a good idea. Not using independent experts, not actively investigating. This was a quote from a judge. They just sit there. Short-term reforms, I think they can be boiled down into really to more consistency across the state, a statewide system, more training, this business about must be changed, become more client-focused. I didn't get a lot about what exactly they mean, but I think they're talking about, what we just talked about before about what we're not doing. Mandatory caseload standards, I didn't get a clear sense of this study what they thought that number should be. There's no magic number, but at least it should be talked about. Obviously, that's an issue in the larger counties. And then reimbursement on an hourly basis. They didn't like that. The study seemed to think that the contract attorneys and the flat fee per case is not a good idea, and youth participation. Long-term goals. Well, that boils down to more money. They're talking about setting up and, no way in hell we're going to get something where we have an administrative office of the courts to oversee this, at least not in this point in time. Client-directed model, you can read those kinds of things. Oh, and the renovates the court facilities to make them adequate for the needs of the children. Would not be easy. So, if you want to take a closer look, there's interesting stuff in this report. It's a lengthy report. It has a very good index, very good table of contents, so you can work through it and look at some of the particular pieces you want, and you can get there's all kinds of tables about how many attorneys responded, how many GALs, how many lawyers, or how many caseworkers, and what they had to say, and what the children have to say. So it is interesting reading. Now, it's Friday afternoon, okay. I'm going to try to tell a story. Okay, because I'm going to figure that I'm going to be doing this talking to people more and more in the last couple of years, so I'm going to try to tell this story. I'm not very good at stories, so you're good. I'm practicing on you. Okay. There was a cruise ship. And on this cruise ship, there was a magician doing his show. And one night, on the front row of the audience, the captain was there. And she had on her shoulder a parrot. Really smart parrot. The parrot figured out all of the tricks the magician was doing, which didn't make the magician very happy. The magician was getting very unhappy with the parrot, because the parrot kept saying things like, cards up your sleeve, cards up your sleeve. every trick. So the parrot and the magician are glaring at each other, and obviously they don't like each other very much. Well, later that night, cruise ship has a big explosion. Thing blows up. Next thing you know, the magician finds himself in a lifeboat, opens up his eyes, and the only other thing in the lifeboat is the parrot. So here's this parrot and this magician. They don't like each other. They're alone together in a lifeboat, and they're just glaring at each other, not saying a word. Finally, the parrot says, "Okay, I give up. What'd you do with the cruise ship?" How'd I do?